Good morning, and I think that we are having a very, very exciting and interactive session, don't you think? And the conference has been a success so far. Give yourselves a round of applause. And with the addition of Baroness Scotland with us this morning, the discussions have automatically become richer. That the conventional approaches in the criminal justice system have not worked, that the criminal justice system in the Caribbean are in crisis, that the criminals and violent criminal conduct are winning the battle, and that if the law is to triumph over criminal conduct, there must be new and innovative changes, are all axiomatic realities already accepted in the Caribbean and indeed at this very conference. It is as a direct recognition of this unfortunate reality that we are gathered here in an effort to reshape and reform the criminal justice systems in the region. As we embark upon this reformation exercise, modern and innovative legal concepts are considered and implemented. One of the new and emerging concepts now gaining traction in the region is restorative justice. Though new in the Caribbean, restorative justice has been around for nearly 50 years and is widely practiced in first world jurisdictions including North America and Europe. Since 2005, the United Nations Congress on Crime Prevention and Criminal Justice recognized restorative justice as a crucial mechanism in enhancing criminal justice reform and recommended that all member states introduce it into their legal systems. A presenter at that forum, making out the case for restorative justice, pointed out that over 100 countries already use some form of restorative justice practice in addressing crime. He posited thus, and I quote, "Restorative justice has become a global phenomenon in criminal justice systems, resonating with, and in some cases drawing from, indigenous conceptions of justice. It offers both an alternative understanding of crime and new ways of responding to it," unquote. Novel concepts such as restorative justice have emerged because the traditional systems of punishment have simply not worked. History and experience have taught us that punitive sanctions are not the solution. We have tried protracted custodial sentences. We have tried the death penalty. We have tried the cat o' nine tails. We have tried hard labor. We have tried solitary confinement. But what is the result? Has there been a reduction in crime? Were these punitive sanctions a deterrent? The answer is no. The harsh and inconvenient truth is that despite the use of these highly punitive sanctions, including death, crime has not only increased, but has increased to unprecedented levels. This morbid reality demonstrably establishes beyond doubt that penal sanctions and the conventional approach to punishment have abysmally failed to achieve the conceptual objective of deterrence. The skyrocketing rate of recidivism further establishes that penal objectives of rehabilitation and reformation are more elusive than attainable. It is against this backdrop that criminologists and sociologists have been exploring alternative methods of dealing with deviant behavior and criminal conduct. In terms of punishment and being guided by the relevant empirical data, they have shifted the emphasis from penal sanctions being punitive to it being more rehabilitative and reformative, with the ultimate aim of ensuring a smoother reintegration of the offender into society. Restorative justice has emerged as one of the vehicles to convey the offender to this destination. Tony Marshall, in his work, The Evolution of Restorative Justice in Britain, European Journal on Criminal Policy and Research, 1996, defined restorative justice as, and I quote, a process whereby the parties with a stake in a particular offense come together to resolve collectively how to deal with the aftermath of the offense and its implications for the future, unquote. Meanwhile, John Braffitt, writing an article titled Restorative Justice for a Better Future, published by Dalhousie Law Review in 1996, observes that restorative justice involves, and I quote, restoring victims, a more victim-centered criminal justice system, as well as restoring offenders and restoring the community, unquote. Yesterday we discussed at length plea bargaining. One can easily discern similarity in attributes and characteristics with restorative justice. Like plea bargaining, restorative justice brings the offender and the victim face to face in a conciliatory atmosphere at a mediation table instead of pitting them against each other in an adversarial amphitheater type setting of a criminal trial court. Whatever the definition is, restorative justice contains three fundamental ingredients: victim involvement, community involvement, and offender integration. In the traditional process, the state is the victim, not the individual. The offender is sentenced and the victim hardly has any involvement. On the other hand, under restorative justice, the victim takes center stage. Property may be restored, compensation paid, dignity restored, a sense of empowerment conferred, relationship with the accused repaired, and a feeling that justice has been done is left in the mind of the victim. In restorative justice, the community also plays a pivotal role. Invariably, the persons who preside over the engagement between the offender and the victim are drawn from the community, from the religious institutions, from community-based organizations, and even teachers from our schools. The offender is offered an opportunity to express contrition and repair the relationship not only with the victim, but with the community which may have been outraged by his conduct. The public shaming aspect associated with the criminal charge, or worse yet, a conviction, under the traditional system disappears. The communal ostracism to which an offender is normally subject is removed. Significantly, the root cause of the problem between the victim and the offender is normally identified and addressed with the assistance of the community. In the end, the process makes it more conducive for the offender to be reintegrated into the community. Yesterday, His Excellency made the fundamental point which I heard being reiterated here today, that it is of paramount importance that we interrogate the situation to get to the underlying cause. Many a times, persons are charged, they appear before our court system, they plead guilty, they are sentenced, and there is absolutely no investigation into what may have triggered or precipitated the conduct that led to the offense that is unlawful. So it's a cycle. The person is charged, he pleads guilty, and robotically he's sentenced and put in the prison system, which we know in the Caribbean is not really reformative and rehabilitative, but that is the subject of another whole symposium. And when that person comes back into society, perhaps goes back into an environment, perhaps it is his home, where the underlying problem is, and still obtains, that sent him into the prison in the first place. That problem has not been addressed. He comes out of the prison system, goes back in that environment where that problem is still resident, and before you know it, the cycle begins again. He is charged because that underlying problem has not been addressed, and he's placed before the court, he pleads guilty, and he goes back into the prison. And that is the recidivism that is so cyclical and so destructive in our criminal justice system. Restorative justice is now being formally introduced into the legal systems of the Caribbean. I believe the first jurisdiction to have moved in this direction was Jamaica, with the enactment of the Law Reform Miscellaneous Amendment Restorative Justice Act of 2016. And according to the Permanent Secretary in the Ministry of Justice in Jamaica, Sancia Bennett Templar, while offering remarks at the 11th Annual Restorative Justice Conference held at the AC Marriott in Jamaica, Kingston, Jamaica in February 2020, she reports that there has been a 90% resolution and settlement rate of referral cases through the restorative justice process. If this rate of success can be replicated throughout the Caribbean, then I believe we would have found a winning formula. Perhaps in appreciating this potential, the Needham's Point Declaration number 35 advocates for its use in the following terms, and I quote, that courts should make greater use of alternative dispute resolution methods, including mediation and restorative justice within magistrate and or parish court for some first-time offenders. We all know that that conference from which the declaration emanated took place in October 2023 in Barbados. However, on the 15th of November 2022, Guyana enacted its Restorative Justice Act. Justice Anderson talked about prescience. We were 1 year ahead of you in Barbados. And I will ask Marlon to put the act up on the screen. Real evidence. You don't need DNA to test that, Justice Mohammed. This is one time where I see witness evidence would be more reliable. So the act is very expansive and very modern. It defines restorative justice in the definition section as restorative justice means an approach to addressing unlawful conduct outside the traditional criminal prosecution proceedings that involves one or more of the following. A, providing an opportunity for the offender and the victim of the unlawful conduct or other community representatives to seek a resolution that repairs the harm caused by the unlawful conduct and allows the offender to make amends to the victim or the wider community. Or B, and this is perhaps the more important one, requiring the offender to obtain treatment or counseling to address underlying mental health conditions, addictions, or other behavioral issues. And here is where focus is placed on investigating the underlying factor. And go to victim, the definition of victim, please. You will note the broad definition of victim. Victim means a person against whom the offense concerned is committed, or who suffers physical or psychological injury or loss or damage to property, and includes, so it's much wider than the whom we will traditionally call a virtual complainant. It includes parent or guardian of a child victim who suffers the physical or psychological injury, loss or damage to property, or B, a person who is financially or psychologically dependent on the victim and who suffers harm because of the harm caused to the victim. So there is a wide bracket of persons who will be part of the restorative justice process and who are likely to receive a positive impact as a result of the process. Compare this to the traditional system, and all these persons are excluded. Certainly excluded from compensation, excluded from the entire process. To the contrary, their involvement will be once necessary to give evidence. And you know, and we know in this room, that the process of giving evidence is not always an encouraging and pleasant one. Because defense counsel do all sorts of things to witnesses in these trials. Section 3 of the Act outlines the main objectives of the Act. A, support the development and usage of restorative justice in Guyana, set up a system of restorative justice that brings together community residents, victims, offenders, and their personal representatives in a permissive, safe, and carefully managed environment. Not that adversarial physical environment of a court. Effect repair in communities that have been damaged by criminal acts or where criminal acts occur. The President yesterday spoke again of the improvements that we have seen, the decline that we have seen in criminal conduct once investments are made. Even infrastructural investments are made in certain communities, traditionally regarded as communities consumed by criminal conduct. Once you give people the opportunity, you give persons alternative activities, you give them economic opportunities, then there is a stark decline and a causal one in criminal conduct, in the rate of criminal charges, etc. Provide and promote a sufficient range of sentences and other means of dealing with offenders outside of the traditional sentencing process. Aid in the public understanding of sentencing practices by providing principles, guidelines, etc. to be applied by courts in sentencing or otherwise dealing with offenders. We just heard a presentation from eminent jurist Justice Winston Anderson on this issue. Provide for the interest of victim and to ensure that their interests are given high priority in the administration of restorative justice. Enhance the rights of victims by providing restorative justice as a way of empowering victims to make decisions about how to repair the work done. Enable access to justice, to restorative justice at every stage of the criminal justice procedure without substituting the criminal justice system for restorative justice or changing the norm normal process of criminal justice. So this is not intended to be a substitute for the criminal justice system. That is why the Act limits its application. If we can go straight to the schedule, there is a schedule at the back of the Act, the second schedule. It lists the offenses to which restorative justice shall not apply. We still have to be conscious of the society in which we live and the nature of that society. While we speak about the softer side of punishment, and in a room like this we can discuss the positive attributes of the softer side of punishment, and we can speak about the ills of the death penalty, the unfortunate reality is, and I switch quickly to put on my political cap, is that the constituency of the Caribbean still wants the harsh penalties and still want the death penalty. So we have to ride both horses, so to speak, straddle both until we find an acceptable medium. Or else I will not be Attorney General to host the next conference. If you understand what I mean. So we cannot ever convey the impression in a crime-infested environment that we are going soft on crime. Our population will not permit that. And it would be wrong in principle if governments were to convey that impression. So pursuing programs such as restorative justice are not intended to replace the conventional criminal justice system or to convey the impression that we are going light on crime. But it is to give flexibility to the traditional system, to add to the traditional system new frontiers that have been tried and tested across the globe and that have worked, as is being seen in Jamaica currently. And Jamaica perhaps represents more than most other territory the litmus test of a Caribbean society. And I say so, DPP, from the best possible perspective. From the best possible perspective. And if it can work in Jamaica, I dare say it can work in any other jurisdiction. And that's the point I want to make. There is also a schedule that suggests a list of offenses to which restorative justice may be preferably applied. But the Act makes it clear of the type of offenses to which it is applicable. Any offenses that carry a penalty of 3 years of imprisonment and below, restorative justice can be applied, except the ones that are statutorily prohibited in the schedule. And of course, restorative justice, as the Act would inform you, and I have no doubt you will read the Act, can be applied like plea bargaining even before the charge is instituted. It can be applied after the charge is instituted. And it can be applied just before sentence is imposed. So the regime for its use and application is very flexible. In Guyana, since we have enacted the legislation, we have been working to prepare the system for this new legal process. And obviously, it must begin with training. So we have done numerous training sessions in order to prepare the system in Guyana to administer and apply restorative justice. These training sessions have include training sessions with our judges, magistrates, prosecutors, police officers, prison officers, probation officers, and community leaders across the regions of our country. These include religious leaders, teachers, as we plan to introduce different forms of restorative justice in our school system. And in the hinterland regions, we have trained our tushaus, or the leaders of the Amerindian communities, in restorative training. We have also trained and certified a cadre of trainers who are qualified to continue these training programs. The training programs are ongoing. We have established, in accordance with the Act, a Restorative Justice Center, which is manned by a director who is here and will join us subsequently in our discussion aspect of this presentation. And he was obviously trained and is qualified to discharge his functions and duties under the Act. Practically, if we are to roll out the restorative justice program nationally, it is obviously a massive undertaking, and it will be a massive undertaking in your jurisdiction as well. Guyana is comparatively a very large landmass. And don't worry about the claim from Venezuela. Don't bother from the claim from Venezuela. Getting there just now. So we have to roll this out across the country. And what we have decided to do quickly, because we have a probation department that is countrywide and that already has an institutional relationship with the administration of criminal justice across the country, both in the high courts and in the magistrates' court in our country, I have decided, with the cooperation of my colleague minister, the Minister of Human Services, under whose ministry the probation departments fall, I have asked her, and she has agreed, for me to put into every probation department in the country a restorative justice unit. So when the probation officer goes to court, that probation officer will go to court with a restorative justice officer as well. Because quickly you will realize the synergy and similarities between the probation department service and the restorative justice service. So there are two services that can be twinned and delivered with great synergy. And we are hoping to capitalize on that infrastructure, which already exists. It will allow us to unfold the restorative justice across the country. The red flag has been signaled to me. So while I have a lot more to say, I will thank you very much for your attention.
Thank you so very much.
And we'll continue the discussion later.